Welcome to my series on how to buy a home. In this episode, I'm going to be reviewing a very important document in the home buying process called the Exclusive Right to Buy Listing Contract. This is an agreement, a form that was written at the state level by attorneys with the Colorado Real Estate Commission. It's written to protect you and give parameters and explanations of the level of service that I'm to provide to you as a licensed real estate broker. And it's also a document that I referred in my brokerage disclosure to buyer video, which talks about these relationships specifically. And as you might recall, if you watched that, by default, I'm a transaction broker. And if you want me to go above and beyond that to serve you as an agent in a formal sense, this is that contract that I reference. This is the contract that stipulates the role of service that I'm required to provide to you by law. The format that I'm going to use as I go through this is I'm going to highlight some important things for you to know about. I'm also going to review the blanks that we have to fill in. So those are discussions that we'll have as far as the parameters, the time frame, what have you related to this agreement. And then I'm going to skip over some stuff just because a lot of it is straightforward. You can read that yourself. And then if you have questions, you can ask me about that as well. So we'll go ahead and get started here at the top and review all the important information related to this exclusive right to buy listing contract. I'll read these highlighted statements here to you at the top, and I've highlighted other aspects of this contract. These are all added by me. They are not what you'll see when you get this official document that we filled out and you're ready to sign it. But I did this again to point out that there's some important aspects of this form. All of it essentially is important, and you should read all of it. But these are some things that require your immediate attention in some cases. For instance, the first line that I'm going to read to you here that states, "This is a binding contract. This form has important legal consequences, and the parties should consult legal and tax or other counsel before signing. In the state of Colorado, you're not required to have an attorney as part of a real estate transaction, as you are in other states, mostly on the East Coast. But if you want to consult with one for the purposes of buying a home and having someone review the documents and the contracts with you, this would be a good time to get started. You can get in touch with me. I have references for local attorneys, real estate attorneys that can help you, as well as tax accountants or professionals and others, depending on what kind of advice you want to have. So if that's something you need, let me know and I can get you connected so that you are fully informed before signing this document." The next statement says, "Compensation charged by brokerage firms is not set by law. Such charges are established by each real estate brokerage firm." So that basically means the commission that I charge for my services to you is flexible. It's based on what my brokerage allows me to do. Now, my brokerage does not require me to do a certain amount. So that's up to me and you to discuss. I do have a standard that I typically charge for my services. That is something I can share with you, and we can discuss what that involves, especially as we discuss some of the options here later on in this contract. The next sentence that's important to understand is different brokerage relationships are available, which include buyer agency, seller agency, or transaction brokerage. Now, I want to reference again my video on the brokerage disclosure to buyer. I do go more in depth in explaining the difference between a buyer agent and a transaction broker. So I'd encourage you to see that if you haven't. But it's important for you to understand this because as we're filling out this contract, one of the first decisions you have to make is checking one of these boxes right here. Either I can serve as your buyer agent, again, that's where I'm your advocate and your fiduciary, or you can have me serve as your transaction broker. And again, that's more of a facilitator. I can't give you advice or advocate for you. I will say that later on in this contract, you'll see there's an option for me to change my role with you. So we can click the buyer agency box, but if you end up wanting to buy a house in which I am the listing agent for the seller, and they agree to as well, I can serve as a transaction broker for both of you in order to represent the transaction and handle both sides of the transaction. So that is an option. There's a change of status form that we can fill out later on if that comes up. But if you want me to serve as your agent right out of the gates, then we'll check that box and move forward in that capacity. Let's scroll down to the first section of this contract, where it states, "This agreement, buyer and brokerage firm enter into this exclusive irrevocable contract, also known as the buyer listing contract, and agree to its provisions. Broker on behalf of brokerage firm agrees to provide brokerage services to buyer. Brokerage firm will receive compensation as set forth in this buyer listing contract." And I'll cover that later on when we get to that section. Section 2 talks about what type of firm I work for. It's a multiple person firm, meaning that there's more than one broker working in the brokerage firm. For Section 3, the defined terms, as you can see, I have buyer highlighted here. This is how we want to have your name throughout the rest of all the documents that we'll be doing when it comes to purchasing a home. So this is how you want your name to appear on title when you purchase the property. This should also match the documentation like the loan application. So whatever documents you're filling out with your lender, if you're working with one, should also match what you have here in this form and all the documents related to the purchase of a property later on. A lot of people will put first and last name. They might throw in a middle initial or their full middle name. If you want to do an entity, I should add that's something we want to do some due diligence first to make sure that it's okay with the lender if you're working with one, or your financial advisor, or whoever you need to consult with to make sure that you have that name proper. We can always fix it later on, but ideally, if we get it right here, it'll be consistent throughout the rest of the documents and there won't be any issues. Section 3.4 talks about the property. This means property means real estate which substantially meets the following requirements or is acceptable to buyer. We could put a specific type of property here or an address. Most of the times with my clients, depending on what works for you, I put a very vague general term like a single family home in northern Colorado with 3 beds, 2 baths, whatever. And that way it gives us some flexibility as far as the type of property that you want me to secure for you. Then scrolling down here to section 3.6, the listing period. This is the period that we determine how long this contract will be active. By default, I usually put 6 months. And then if we take longer than that, we can do an amendment to extend that period. By law, you cannot exceed 1 year. So we could also do 1 year. It just depends. This is something that we can talk about and see what's going to work for you. Now I want to scroll down to section 4 here. And this talks about the brokerage relationship. And I'll go ahead and read section 4.1 to you. It says, if the buyer agency box at the top of page 1 is checked, broker represents buyer as buyer's limited agent. If the transaction brokerage box at the top of page 1 is checked, broker acts as a transaction broker. Now 4.2 talks about some protections and allowances. It talks about how when the seller and buyer in a transaction are working with different brokers within the same brokerage firm, those brokers continue to conduct themselves consistent with the brokerage relationships they have established. Buyer acknowledges that brokerage firm is allowed to offer and pay compensation to brokers within the brokerage firm working with the seller. So this means that if I'm working with you as the buyer and one of my colleagues in my office is representing the seller, I'm going to have the consistent relationship with you as we decided at the top of page 1. And I'm going to represent you fairly and protect your interests. And so you are protected in that regards, but it also states that we are allowed to do those kinds of interactions or transactions where I work with you and then the seller is represented by somebody that I know that works in my office. So it's not a conflict of interest or anything like that. 4.3 talks about the different options that are available should I represent both you and the seller. And it states if the seller and buyer are both working with the same broker, broker will function as 4.3.1 talks about buyer's agent. That's the first option. And if that's the case, I'll read this paragraph in 4.3.1.1 where it says broker represents buyer as buyer's agent and must treat the seller as a customer. Now I want to point out if I treat somebody as a customer, I don't owe them any of the uniform duties that are described in section 5 below, or the agency duties described in section 6. Those are the duties that I'm applying only to you. So I owe them nothing. I can't give them advice. I can't counsel them or anything like that. It's simply just a customer. They have to represent themselves and handle things of their own accord. I can't help them out in any way. And then it goes on to say a customer is a party to a transaction with whom broker has no brokerage relationship. Broker must disclose to such customer the broker's relationship with the buyer. However, if broker delivers to buyer a written change of status that broker has a brokerage relationship with the seller, then broker is working with both buyer and seller as a transaction broker. So that means you have the option, if you want me to represent you no longer as an agent, but as a transaction broker, then I'm allowed to work with the seller as a transaction broker as well. And that is a relationship change that requires that change of status form that I mentioned earlier. And that's also stated here in this paragraph. So if the box in section 4.3.1.2, as you can see there below, states buyer agency only is checked, then buyer agency only applies instead. So if you just want me to work as your agent and not change the status of that relationship throughout any transaction we might be involved in, then we can check this box in 4.3.1.2. 4.3.2 talks about another option, and that's where I work as a transaction broker. So if the transaction brokerage box at the top of page 1 is checked, or in the event neither box is checked, broker must work with buyer as a transaction broker. So by default, again, I work as a transaction broker. A transaction broker must perform the duties described in section 5 and facilitate purchase transactions without being an advocate or agent for either party. If the seller and buyer are working with the same broker, broker must continue to function as a transaction broker. So those are the different options moving forward if I'm working with you as the buyer, whether I'm working as your agent, or we can change that to a transaction broker if you want me to go ahead and work with the seller in that capacity, if it's a seller I'm working with, or I have to treat them as a customer if you'd prefer me to stay as your agent. So those are the options that you have. Let's look at section 5 where it talks about my brokerage duties to you. And if you saw my brokerage disclosure to buyer video, that also lays out exactly the services I need to provide to you. However, in the actual contract that we're reviewing right now, it lays out a few more details about things that I must do in response to serving you, as well as your protections, as you'll see. It states broker acting on behalf of brokerage firm as either a transaction broker or a buyer's agent must perform the following uniform duties when working with buyer. And as you can see there, I must exercise reasonable skill and care for buyer, including but not limited to the following: performing the terms of any written or oral agreement, presenting all offers to and from you in a timely manner, regardless of whether the buyer is already a party to a contract for the purchase or lease of property, disclosing to buyer adverse material facts actually known by broker, and that can refer to things about the home, related to the property or the neighborhood or those kinds of things. For instance, if it's in a metropolitan district, or if that neighborhood had some particular issues with water lines, what have you. If I know about that, I'm required to disclose that to you so that you are informed and can make the best decision moving forward. I have to advise you, the buyer, regarding the transaction and advise you to obtain expert advice as to material matters about which broker knows, but the specifics of which are beyond the expertise of broker. So I might refer you out to talk to people like, here's what I think, but you should talk to this person, or here's a list of professionals I can refer you to that can help inform you better so that you know more specifically what's going on with a particular matter about a property. And then 5.1.5 says accounting in a timely manner for all money and property received. The next one says keeping you fully informed regarding the transaction. So making sure that you're fully aware of what's going on, what the listing agent is telling me, and any updated information so that you're able to stay on top of things and better negotiate when we come to different decisions and various aspects in a transaction. 5.2 is also an important thing. Those are the things I just mentioned are things that I must do for you. However, 5.2 talks about things I must not do without your informed consent. And the first one says that buyer is willing to pay more than the purchase price or lease price offered for the property. So I can't disclose to a listing agent that you're willing to pay more for the property, for instance, in a multiple offer scenario or competitive offer scenario. I can't say to that listing agent, hey, the buyer's willing to come in a little higher, so don't forget about us. We're willing to negotiate. I can't do something like that unless I have your permission. Also, I can't share what your motivating factors are. A lot of times people ask me, well, why does the buyer want to buy the house? Or, why are they moving to the area or what have you? Unless you give me permission, I don't share that information. The next one states that buyer will agree to financing terms other than those offered. So if we put in the contract that you're going to come in with a conventional loan or a VA loan or an FHA, I can't let them know that you're willing to change your loan that might be more agreeable to a seller unless I have your permission to do that. Next one states that any material information about buyer, unless disclosure is required by law, or failure to disclose such information would constitute fraud or dishonest dealing. So I can't just share information about you unless it's required, such as the ability to perform the financial terms that we put in the contract. And then 5.3 talks about buyer consents to broker's disclosure of buyer's confidential information to the supervising broker or designee for the purpose of proper supervision. So I can't talk with my supervisor if something comes up and I'm like, hey, I got a question about this. I need a second opinion. And so I am allowed to disclose that information, but it's not something where I talk about it with a bunch of other people in the office, or especially if the listing agent also happens to be in my office. I will make I'll be very careful to make sure that they don't learn anything about you in the conversation I have with the supervisor. 5.4 states that the broker may show properties in which buyer is interested or to other prospective buyers without breaching any duty or obligation to buyer. So that means I'm allowed to show the same property you're interested in to other buyers that I'm working with. And this is not a conflict of interest, or it's not a breach of contract or anything like that. It's just the nature of doing business. And it says broker is not obligated to seek other properties while buyer is already a party to a contract for the purchase or lease of property. So I'm not obligated to, but I have had it happen where we know we're going to terminate because there's a legitimate reason for the buyer to pull out of that contract and get their earnest money back. I will go ahead and start pulling out some properties that might work for them and continue the search for them so that they can take a look at those properties and not miss an opportunity potentially, especially in the last few years with this fast moving market. I think that's just a good service to provide to buyers to make sure that they don't, like I said, miss an opportunity. 5.6 states, broker has no duty to conduct an independent inspection of the property for the benefit of buyer and has no duty to independently verify the accuracy or completeness of statements made by a seller or independent inspectors. Broker has no duty to conduct an independent investigation of buyer's financial condition or to verify the accuracy or completeness of any statement made by buyer. So I'm going on good faith that you and or the seller are telling me exactly what the truth is. It's not my job to verify that information. And then just as I must disclose adverse material facts to you about a property, I also must disclose to any prospective seller all adverse material facts actually known by me, including but not limited to adverse material facts concerning buyer's financial ability to perform the terms of the transaction and whether buyer intends to occupy the property as a principal residence. So those are some things that I do have to share with a prospective seller. And then buyer understands that buyer is not liable for broker's acts or omissions that have not been approved, directed, or ratified by buyer. So I'm not going to do anything without your permission. What I'll do, I'll have an idea, for instance, an idea about the best way to negotiate moving forward. I'll bounce that off you. We talk about it. And with your permission, I'll do exactly what you tell me to do based on the advice that I've given you. And then section 6 talks about the additional duties of a buyer's agent. So section 5 talks about the uniform duties related to that of a transaction broker. But if you want me to be your agent, not only do I have to do all of section 5, but I also will add section 6 as the additional duties of a buyer's agent. And with that, I have to promote the interests of you with the utmost good faith, loyalty, and fidelity. I have to seek a price and terms that are acceptable to you. And I have to counsel you as to any material benefits or risks of a transaction that are actually known by me as your broker. Section 7 talks about compensation to brokerage firm, or to put it another way, how I get paid for my services to you as a buyer. In consideration of the services to be performed by brokerage firm will be paid as set forth in this section, with no discount or allowance for any efforts made by buyer or any other person. Unless otherwise agreed to in writing, brokerage firm is entitled to receive additional compensation, bonuses, and incentives paid by listing brokerage firm or seller. An example of that would be sometimes with the motivated seller, they'll pay an additional $2,000 or $3,000 on top of the normal commission that they're going to pay if a buyer's agent can bring a buyer and close by a certain date or a certain deadline. You'll also see this with developers and new construction communities. They'll also incentivize buyer's agents to bring somebody in and close by a certain date on a particular property or several properties to receive an extra bonus. And that, as we see here in this paragraph, is something where I'll inform you of any such additional amount to be paid to brokerage firm. And if there's a written agreement, broker will supply a copy to buyer upon written request to buyer. And then we move on to section 7.1, and it talks about the success fee. And this is where it gets specific about how I get paid. I typically charge 2.8% of the purchase price for the services that I provide. And as we see here in section 7.1.1.3, it says when earned, when payable, talks about the success fee is earned by brokerage firm upon the purchase of the property and is payable upon closing of the transaction. If any transaction fails to close as a result of the seller's default with no fault on the part of the buyer, the success fee will be waived. If any transaction fails to close as a result of buyer's default, in whole or in part, the success fee will not be waived. Such fee is payable upon buyer's default, but not later than the date that the closing of the transaction was to have occurred. Now, I have had situations where a buyer had to default, they had to terminate because of a family emergency, what have you. That's all negotiable. I'm not going to make somebody in a bad situation pay me for services in a situation like that. Again, everything's negotiable. So that's a bridge that we'll cross when we get to it. As far as an hourly fee, I don't charge that. I don't charge a retainer fee, but those are all things that you may come across when you're working with particular agents. A brokerage firm for lease, I don't do that. But who will pay the brokerage firm success fee? Section 7.3. I typically check the box for 7.3.1 as I have highlighted here. It says the listing brokerage firm or seller may pay, but the buyer is obligated to pay. Basically what this means, as stated in this paragraph, is broker is authorized and instructed to request payment of brokerage firm success fee from the listing brokerage firm or seller. Buyer is obligated to pay any portion of brokerage firm success fee, which is not paid by the listing brokerage firm or seller. Now, this is one of those things where it just depends. Again, everything's negotiable. If I'm getting paid a satisfactory amount from a listing brokerage firm or seller, I'm not going to charge you additional money. Where this really comes into play, though, is when we're talking about a for sale by owner. In some instances, people that are selling their home on their own will not pay any compensation to a buyer's agent. And when that's the case, then we talk about how am I going to be compensated? If they're not going to pay me, how are you going to pay me? And what is that going to look like? So again, everything's negotiable. I do have a standard fee that I charge for my services. I work hard, and it's typically 2.8%. But if we come across situations where the seller is not paying or paying a very minimal amount, that's something where we're going to have a discussion about that. The other options for who will pay the brokerage firm's success fee include buyer will pay, or the listing brokerage firm or seller may pay, but the buyer is not obligated to pay. Those are things that we can discuss. But like I said, I typically check the box for 7.3.1. Now, looking at the holdover period, I'll read this to you. Basically, it's talking about if I've negotiated on your behalf for a property, and if I've submitted its address or other description in writing to you during the listing period, if after that listing period expires and you close on that same property with another agent, then you owe me a success fee. Where this comes into play is when an agent is working with someone and the listing period is about to end and they know that, and either one, they try to negotiate with the seller to save some money for both parties and kind of cut you out of the deal, or a buyer might have a relative, a cousin, a friend, a nephew, niece that just got their real estate license, and they're like, oh, that'd be fun to work with you and close on this property. If that's the case, you as a buyer would owe me a success fee in a situation like that. Now, personally, I work on good faith. I like to think that buyers are not going to do that kind of thing and try to cut me out of the deal after I've done all the work of finding them a specific property and negotiating on their behalf for that specific property for information, what have you. But, it can happen out there. People do things that are less than desirable. But that's something we can discuss as well, how long that period is or what have you. And then as we scroll down here, Buyer's obligations to broker in Section 9. It says buyer agrees to conduct all negotiations for the property only through broker and to refer to broker all communications received in any form from brokers, prospective sellers, or any other source during the term of this buyer listing contract. Buyer represents that buyer, and then we check the box, typically is not currently a party to any agreement with any other broker to represent or assist buyer in the location or purchase or lease of property. Buyer further represents that buyer has not, is typically the answer to put there, received a list of any submitted property pursuant to a previous listing agreement to purchase or lease property with any other broker. So basically that means you are not working with anybody else, so that with confidence we can move forward signing this contract and not have to worry about any issues with other agents claiming they're working with you and causing some disagreement or some issues down the road. Section 10 talks about if either you or myself are in default, either party has the right to cancel. So essentially we have the right to fire each other. I'll let you read through that as it discusses the parameters and the circumstances under or in which you have the right to do that. Section 11 talks about the cost of services or products obtained from outside sources. Broker will not obtain or order products or services from outside sources unless buyer has agreed to pay for them promptly when due, such as surveys, radon tests, soil tests, title reports, engineering studies, or property inspections. Neither broker nor brokerage firm is obligated to advance funds to you, the buyer, to pay for such services. Buyer must reimburse brokerage firm for payments made by brokerage firm for such products or services authorized by buyer. So if we do arrange it that way, that I pay in advance, you're obligated to pay for that, those services that I covered for you. Section 12 talks about my services as far as showing properties. 12.2 states that buyer acknowledges that broker has explained the possible methods used by listing brokers and sellers to show properties and the limitations, if any, on buyer and broker being able to access properties due to such methods. Broker's limitations on accessing properties are as follows. I typically state those that are ordinary and customary, in addition to any special limitation placed on showing by the owner or listing broker of the property. Now, as you can see in that next segment below, I utilize Iris and RE Colorado. Those are the two main MLSs along the Front Range of Northern Colorado and even the Denver area and beyond. And if there's a listing that's on the MLS in the area, I have access to it. And when I request a showing for these properties, they will have specific parameters under which we're allowed to see the properties, such as timeframes. Are we allowed to bring children in? Those kinds of things. That was more of a COVID thing. But even now, sometimes they have special instructions about looking at properties. And some of that can be determined by what the seller's availability is. Maybe they still live in the house and they work at home. And so they don't want people coming in at all hours of the day, and you have to schedule a time that's not going to interfere with their ability to do their job at home. Sometimes if there's a tenant still living in a property, they might have very tight restrictions on when they're willing to allow prospective buyers to access a property as well. So those are some of the things that we can run into as far as requesting showings for property. Section 13 talks about the disclosure of buyer's identity. I typically check the box for does. So it states broker does have buyer's permission to disclose buyer's identity to third parties without prior written consent of buyer. This comes in handy when I'm trying to arrange for an inspection to be scheduled on a property that you're under contract with. And I want to make sure that we can get them in there in time before the deadline. And so if you agree, or if you give me some dates and times that work for you to go to the inspection, I will talk to the inspector on your behalf and arrange for that and give them your contact information so that they can reach out to you and discuss with you all the aspects of the inspection, whether you want a radon test, a sewer scope, what have you. This also works if we're getting a survey. I can reach out to a surveyor and I'll give them your contact information so that when they're done doing the improvement location certificate or survey, they can contact you to arrange for that or share any other information, payment, what have you, for their services. Jumping down to section 15, wire and other frauds. This has been an issue. Usually it's in the case of wiring funds to closing. So you as the buyer will have to wire certain funds to closing, a certain amount rather. And some people will hack into a real estate agent's email or the title company's email, and it'll look very authentic, but they will have a phone number that is different than that title company. And so when you call them, they'll give you wiring instructions, but they're actually giving you instructions for a different account than what is for the Fidelity National Title Company or Land Title or whatever the case may be. And so you will send all that money to a thief and you will never see that money again. And so that's why it's very important that when it comes to wiring funds, that you call the number that I'll give you, and the title company will be the number for the authentic title company, and they'll give you in a secure line all the wiring instructions so that you can send the money to the right account, and we don't have to worry about you being defrauded out of a lot of money. Scrolling down to 17, it's pretty obvious, but non-discrimination. Buyer understands and agrees that the broker may not violate federal, state, or federal, state, or local fair housing laws. It's just the way it is, and it protects everybody. And I've never really had issues with this, obviously, but it's most people are very fair and reasonable and aren't interested in discrimination. Section 18. Recommendation of legal and tax counsel. This is just reiterating what was at the very top of this contract. By signing this document, buyer acknowledges that broker has advised that this document has important legal consequences and has recommended consultation with legal and tax or other counsel before signing this buyer listing contract. Section 19 talks about mediation if a dispute arises. I'll let you read that. Attorney fees. That's also if there's a dispute that arises. Who will pay for those attorney fees? It's the prevailing party. Additional provisions. Sometimes there's specific provisions that you want me to perform in this relationship, this contract. We would put that there. And then scrolling down, physical delivery and notice. You'll receive all documents related to this contract, as well as all other documents related to any transaction that we're involved in. Electronic notice. This means that you agree as an alternate to physical delivery. Any notice may be delivered in electronic form to brokerage firm or buyer or any individual named in this buyer listing contract to receive documents or notices for such party at the electronic address of the recipient by facsimile, email, or text message. And then scrolling down, a lot of this is boilerplate, again, put in there by the real estate attorneys at the state level. So read through those things. It's all good information. It's important for you to know that. And then section 27, entire agreement. This agreement constitutes the entire contract between the parties, and any prior agreements, whether oral or written, have been merged and integrated into this buyer listing contract. So this covers the entire contract, that exclusive right to buy contract. You will get a receipt of a copy of this buyer listing contract signed by you as well as me, so that you can have that in your records and as a reference. And then, of course, Megan's Law here, section 29. If the presence of a registered sex offender is a matter of concern to buyer, buyer understands that buyer must contact local law enforcement officials regarding obtaining such information. That's not something that I can provide, but I can point you in the right direction. So that is the exclusive right to buy listing contract. I hope this was helpful. If you have any questions about it, especially as it pertains to you and I filling out this contract as it pertains to the services that I provide to you, we'll have that discussion. But don't hesitate to reach out. You can reach me here at 970-313-6706. And we'll look forward to talking to you soon. Take care.